Back there, I don't want you to have to stand through the whole thing. There are seats available. There are seats in the front. There's seats somewhere in here. So please don't, and if you need more chairs, we'll get them for you. But I don't want you to be uncomfortable. Okay, I was going to go ahead and jump in and tell you about the structure of our regional center. But I think that following Laura, if Steve will come in, since she did touch on the SEC issues, Steve is also very familiar with our business plan, and he's going to probably be able to pepper a few comments with our own actual structure. And then I will go in, because I don't want to take too much time. And my structure is very simple. But I did forget to recognize someone. I had not looked at him as I was addressing everyone. I apologize. Tom Caseville was very crucial. He was part of our team in assembling the information for the business plan and also putting it together in format form so that it would be picture perfect for the federal government to be able to evaluate. Thank him very much for his help. He too was very supportive of the city and the fact that our economics are not exactly where we should be, but I hope that as we get our regional center working more and more, there will be more income coming in. One thing I want to touch upon before Steve goes into his presentation is something that the mayor touched upon, which I think is very, very significant in our case. Our business plan is very unique. And the business plan came together as a result, as Laura said, of my really looking at every regional center operating in the United States and actually getting in the car, driving up there, and sometimes flying to see what they were doing. And in some cases, it looked very good on paper, and then you drove up and there was this empty lot. There was nothing there. So as a result of that, I really got the do's and the don'ts. Our business plan reflects that. But in understanding our business plan, since it's unique, the city will be able to make money off of this because by law or by regulation, you know, the regional centers make profit not just for the project, but also should make some kind of profit for the city, and usually it is by way of taxes that are paid, fees that are paid. But in our case, we are going to be doing pretty much what Vermont has done, other regional centers, which is there will be an application fee. So developers that come in, or as Laura said, this is not just for residential developers. This is open to probably almost any enterprise so long as it meets our business plan requirements and the federal government. And I can tell you, if you know anything about the Brooklyn Navy Boatyard, if you know about the Philadelphia Convention Centers, these regional this was impartially funded with regional center money. And Steve will touch upon how much capital actually can come or should come through EB5 investors. But if you look at the United States, especially in the last 7 years where the economic crisis smacked everyone and money dried up, if you look at what was done by cities, by counties, states, using EB5 funds, you would be amazed. And that's why there is such a bipartisan support for this. Our plan does in fact do that, but we also have a percentage of the money that we raise as a city going into public safety enhancement. We, by law, are not allowed to use regional center money for general funds. We have our own fund that we have created that had to pass muster by the federal government, where the money that comes from the regional center will go into that fund, and the purpose of that fund is just to continue moving the regional center forward so that more people can be reached, more projects can be accessed. And also, we had a little idea, since we basically are always worrying about the quality of life issues, that why couldn't we do something new and try to get the federal government to approve us taking a percentage of those funds for public safety enhancements, police enhancements, fire, anything to help with the safety and welfare of our people, and they approved it. So in our business plan, you will see that there is a portion of that going to public safety, which we're very proud of. Okay, my counsel is telling me why don't I just go in to do my thing so he can back me. Our regional center is set up in a very structured manner. And I'm just going to give you an example. Let's say you're Mr. X or Miss X and you have a project. Hopefully you are taking away information here and you will do your homework so that when you call me as the managing director of the regional center, I will be your first stop. And you call me and you say, I have this project. And I'm going to say to you, that's very good, but I want you to send it to me via email. You don't have to go into details, but I want everything documented, so please send it to me via email. You write me an email and you say, this is what I want to do, this is who we are, etc. After that, we have a face-to-face meeting, and you tell me all about your project. If the project meets the requirements that we have set as a regional center, which are basically the same requirements as USCIS, you're going to create 10 jobs, you have to be sure that you're financially able to do this, then I'm going to tell you, very well, I need you to go back and you need to prepare a comprehensive business plan. Not a 2-page statement of this is what I want to do, but a plan, just as if you were going to a bank or to any person to ask for some kind of consideration to raise funds. You will bring that plan to me, and we will go over your plan to make sure that everything in your plan is comprehensive enough so that at that point, if we say, this is a pretty good plan, now, should I decide this? No. We have 2 tiers of review at the City of Miami. We didn't have to do that, we could have automatically accepted it, but I felt that there should be 2 tiers of review. Number 1, is this a project that is in line with the mission of the City of Miami? In other words, does it fit into the plan? Does it have a place for it? I mean, do we really feel that this is something we can embrace? Is it a program that if gambling is not allowed, well, then this is not something we can entertain. So to not just go into what our specific mission is, but also, you know, what do we want to do in the City of Miami? Let's say we look at that. How do we look at that? Can it be built? Can this be built? Is this a beautiful project, but realistically, will our planning director like it? Will the City Commission approve it? Will it be able to pass muster at all levels of review, just like any project that comes to the City of Miami would have to? So we've established what we call the interdisciplinary team. This is an internal committee made up by the directors of the major departments. It's project specific. So in other words, if it's a restaurant project, naturally we will get the departments involved. If it's a simply construction project, therefore we will do the same. So the way we put our interdisciplinary team together, we're going to have the director of building, planning, zoning, the city attorney, city manager's office will all be represented. And that group will meet periodically and we will look at the business plan. We will have the business plan before us, we'll take notes. If necessary, we will interview the prospective developer or applicant, and we will ask the questions. Assuming that after that rigorous review, and guaranteed it's going to be rigorous because we're just as good as our projects. A regional center is just as good as the project it promotes. Not only do we have a responsibility to our city, our citizens, but we have a responsibility to the investors. A lot of these people are not billionaires out there in, you know, other parts of the world. These are hard-working individuals who many times have just put together enough money to be able to do this, because remember, the EB-5 visa is not just for the investor. It's for the investor, spouse, members of the family, children under 21, okay? So with one investment, it's possible you would have 5 visas, okay? So a lot of these people in other countries have worked very hard to have their money together. They're not, as some people think, you know, these multi-billionaires coming to the United States. So our responsibility is not just to the project, but also to those investors, because this is not a risk-free venture, and we have to protect them. It's our integrity. We have to protect them. So what we do is we sit down, we look at that, we say, okay, financially, what do you think, Mr. Finance Director? We go through that whole review. After that review is done, we tell the applicant, you know what, we believe that this is a project that is right in line, good for the city, good for the citizens, good for you, and we'd like to take it now to another layer of review, which is where we look at it as far as EB5 worthiness. Is this a project that will pass muster under strict EB5 regulations, under SEC rules? And for that type of council, we have a group of people that, again, it will be project specific. So there are people all over the United States who would help us in their volunteer capacity to come in, along with our attorneys, and look at that project for EB5. Is this something that we can safely say, we think this is a good project for investors? At that point, though, we would have a higher level of scrutiny where financials would have to be put together, basically what offering documents are going to be offered to the investors. At that layer, it's very, very strict. If that group says, you know what, this is something that, again, we feel is worthy, should be undertaken, then we move on, we go on. Developer or applicant takes his project, has it get ready with their own lawyers, their own attorneys. Our attorneys do not represent the people that come before us. That particular group basically goes, gets their developer project done, and gets ready to go to market. When it goes to market, that means that it comes under the City of Miami's portfolio, so to speak. By law, the City of Miami, as a public entity and under SEC rules, cannot go out and market a specific project. When we did our hypothetical, that is the only project. But once we get all our projects to market, we offer, let's say we have 3 projects, what we do is we say, this is what we have. This is the City of Miami Regional Center. We have our projects, Mr. Investors, and believe me, there are many, many projects competing for, investors. Nowadays, there are more investors with more savvy lawyers who are going to take a look at each project because they don't want their people to get stuck, make mistakes. So we've got to make our project so attractive in the sense that it's not just because we're Miami and we're the pizzazz group. We're Miami and we have a great project or projects for you to look at. At that point, that project goes what we call to market. Now, what does that mean? And Steve and Laura can chip in. We as the city have undertaken in our application the responsibility for letting as many foreign investors, as many countries in the world know that we have a regional center. But again, since we cannot market a project specifically, let's say we go to an event where there are several exhibits, we can say, this is our portfolio of projects, and then we offer it as such. Now, if the developer, the project applicant wants to go hire their own people to market it, they can do that, but there are some very strict rules for that. And that's why Steve is going to be sitting in the important chair here, because he's the one who's going to scare us. The reason is that we are as good as our projects, and we want to be sure that the law is totally followed at every point. So that's how the process works within the City of Miami. Now, what kind of projects and how much? In the application, we have to specify that we would take projects maybe that would not require below $10 million and exceed. You can go as high as you want, but that is very flexible. In other words, we're not going to turn a project away because the amount of capital that you need to raise is not that number. Okay, we specifically want to be sure that we open this, but again, I remind you, this is all subject to USCIS general regulations, which is what Laura and Steve will add to this. What we will do is we will assume a sort of like a floating criteria in terms of how much interest the city will receive from the amount of money that is raised. And I'll tell you why this is the nice part of our business plan. The way we're going to raise money for the city is twofold. We're going to have an application fee, which is the applicant has to come together and bring his packet, but it takes resources, it takes time to go over each application. This is standard operating procedure. The application fee we will charge will depend on the project, will depend on the applicant. We have a lot of not-for-profit groups that may want to access the regional center. We have colleges, universities, public hospitals. We're going to be very flexible in making sure that those people have every access to the City of Miami Regional Center. Same thing that we have in terms of how we're going to make money. We are going to receive a percentage of the money raised by the specific project. Okay, so let's say a project raises $10 million, and I'm giving you an example. The city then will enter into an agreement. Before anything goes, the city has to enter into an agreement with the applicant whose project we are accepting. And in that agreement, we will say, okay, sir, lady, madam, you will charge us, and we will charge you X% for the money raised. But again, because we're a city, we want to be open, we're going to charge as little as a 0.5 to as much as a 4%, which is very competitive in today's market if you went out to raise money. Why the sliding scale? Again, because we want to ensure that we help people as opposed to get rich from people. The city's not here. This is not our business. Our business is to try to help the citizens and also try to fund the project, fund the program so we can continue to do it. It takes time, it takes effort. So I want everyone to be clear on that. I think that's the beauty of our business plan. That not only is the city providing a great service, but it will be able to reap some funds to put back into the public safety aspect of our city, as well as in continuing the program. Okay? I think that's about all that I need to say in terms of how our program works. Our website is being developed. It will be a very comprehensive website, and in the website you will have all of this information. One thing I want to be very clear on that Steve will definitely touch upon, we do not deal with investors' money. We do not touch investors' money. We don't want to touch investors' money, okay? That goes into a special fund that the project itself will create. Now, will we be monitoring? Absolutely. But will we be sure to keep that distanced away? Yes, we will, because that is not something that we believe that as a city we should be doing, okay? Now, at the end of the day, as I said, when I started researching regional centers, there were 200 and something regional centers. Now there are almost 600. So, and most of them, if not, I think most of them are privately owned. And that is why they each have their business plan, they each make money in their own way. There are broker-dealers involved, which we're going to talk about. We do not do that. We will not be hiring broker-dealers. That's not what we do. We're going to market it on our own. We're going to market the regional center. We don't market projects. Okay? If I've forgotten anything, I'm sure it will remind me, but I want to turn it over to Steve. And I also want Tom to feel comfortable in just letting us know if there's anything that we forget. And again, please be sure to get a seat. How does he flip to the monitor? Hello? There we go.
Stand because I have a terrible back. This is.
Would you like to move over here?
This is good. I'll stand right here. Is this on? Great. Well, this has been truly an honor to work with the City of Miami, and especially Mickey Cantone. As a corporate securities lawyer, we're always concerned about dotting our I's, crossing our T's, and she has put me to task. Not only am I asked to make sure that we're complying with the securities laws, but then Mickey will go on and say, well, aside from the securities laws, what other liability might there be, and make sure that you protect the city. So let me just do a quick recap, because you heard a lot this morning. And look, I'm a simple guy from California, and I had the good fortune of being a corporate securities lawyer and getting involved early in the EB-5 arena. And with that, I brought a private equity fund and traditional corporate securities background. But for me, it's about pictures. I learn better from pictures. I'm a visual learner, and I try to take notes when I go to these presentations, but I think a picture says a lot. So early on, you heard my colleague, as well as Mickey, talk about regional center, talk about targeted employment area. So I have a picture on the screen, so you kind of, in your own mind, can see the difference. First, you have this notion of targeted employment area, and why is it important? It's important because that's the level of investment that an investor will make. If your project's in a targeted employment area, 150% of the national unemployment rate, the investment amount is $500,000. If you're outside of a targeted employment area, the amount's $1 million. So if you're a foreign investor and you're interested in putting capital into a project, would you rather invest $500,000 to get the benefits of EB-5, the fifth preference category visa, or would you rather put in $1 million? So you're more likely to get your money if you do a deal in a targeted employment area. The second concept is regional center. I like to think of a regional center as an administrator. The real function of the regional center is to look at projects and say, this is a project I'd like to be associated with. I'll, through a contractual relationship, agree to file certain documentation on an annual basis with respect to the projects that I'm associated with. How many petitions have been filed by investors seeking a visa through our association with the regional center? How many of these, at the end of my 2-9 petition, how many of these conditional cards are granted, how many are denied? So it's more of a statistical reporting that goes back to the Immigration Service. And in exchange for that, they allow these regional centers to exist. They designate them. What's the importance? Indirect and induced jobs. What are indirect and induced jobs? They're the jobs provided by the vendors of goods and services. Because if you think of not W-2s, right, the direct jobs that Laura was talking about. So if I had a restaurant, sure, I have a bunch of W-2 workers, and full-time 35-hour-per-week workers. But what happens if I have a large project that I need to construct? There's not enough operational jobs, these direct jobs that I can garner to fill out that capital stack that I need to make the deal work. So by associating with the regional center, I get to count indirect and induced jobs. I get to count the jobs of the vendors of goods and services. That means construction jobs. If you don't use a regional center, you don't get to count construction jobs. They're deemed to be seasonal and not full-time jobs for the requisite period of time. So you do this not only on a local level, but as Laura mentioned, you can expand beyond the region and go national. Who's milling the steel? Who's going to the local Starbucks? And more orders are now being placed, so we have to hire more people. So there's an economic impact, and by associating with the regional center, project companies, in whatever endeavor they choose to pursue, get to take advantage of the indirect and induced jobs. So in your mind, when you're thinking about things, think regional center, indirect and induced jobs. Targeted employment area, 500,000 versus $1 million. You can have projects in a targeted employment area and outside of a regional center. You can have projects within a regional center and outside of a targeted employment area. You can be outside of both. A lot of my restaurant franchises that I do, they don't need a lot, and they just say, I'm going to be out of a TEA, a targeted employment area, and I'm going to create the W-2s. And then you have the sweet spot in the center where you're taking the opportunity to use the $500,000 minimum investment and the indirect and induced jobs. The City of Miami Regional Center has been established to enable you to take advantage of the indirect and induced jobs, to really show the economic impact of your particular project. The key to this, again, is 10 jobs per investor. So again, when you're looking at the model, is it easier to count 10 W-2s, operational jobs at the hotel, operational jobs at the restaurant, or is it easier to use an economic impact report that truly demonstrates the number of jobs that are created as a result of the project? And you'll get more jobs using an economic impact report reflecting the indirect and induced jobs than you do with W-2s. Now on to my practice area. Being a conscious securities lawyer, let me tell you that what I'm about to say is not legal advice, and I'm happy to talk to anybody after this, but one of the concerns I have in this arena is securities laws are very, very complicated, and the outcome turns sometimes on one or two facts. And I have found over the years when I consult clients, they'll hear something and walk away hearing what they want to hear and focusing on what they wanted to hear. And so I'll oftentimes follow it up in a memo just because when people read things, it reaffirms certain elements and then they can have a reasonable discussion. Let me mention something about the EB-5 arena and us, what we do as corporate securities lawyers. We look at this program as a corporate securities offering with an immigration overlay. Because if you really think about it, while the attractiveness of these offerings is focused on accessing capital from investors seeking a better life here for their families and themselves, at the end of the day, it's a securities offering. You're selling limited liability company interests. You're selling limited partnership interests to foreign investors. And in exchange, they not only get an interest in an enterprise, but they're also eligible to now qualify for this special category of visa. And this is no different than when I do a maritime deal, or I do a deal that has a Federal Drug Administration component, where we bring in regulatory lawyers to focus on that element of the securities offering. When we do an EB-5 securities offering, not only are we intimately working with our immigration colleagues to make sure that the project is designed, that the deal docs are designed to fit within the immigration requirements, the EB-5 requirements, but we're also bringing in other experts within our firm that deal with the specifics of that particular transaction. Because I'm not a real estate expert, so I have to bring my real estate lawyers in. We do deals all over the country. I'm not conversant with laws in Minnesota or New York, but I bring in my colleagues to deal with those special and specific local laws as well as federal laws. Sometimes we do a deal that involves transportation, distribution, and there's other elements. So as you think of the United States, and for that reason, you should take extra care in preparing your securities offering documents, the documents that ultimately go to the investors, so they can make the decision whether to invest in your particular project. I'm going to give you a little example of something that happened a few years ago, because one of the things as a corporate securities lawyer, and as somebody who takes a great deal of pride in doing the right thing for the investor as well as the client, is we do things in great detail. We go through due diligence, our clients, we do diligence projects, we do the things that any reasonable person would do to make sure that it's a viable investment, not from an investment perspective, because we're not investment advisors, but as a securities lawyer to make sure there's full, fair, and complete disclosure, giving people the information that they want to make a decision. The same types of things that you'd want to know. If I were going to sell you something, you'd have a bunch of questions that you would ask. So a few years ago, I was asked to present to the American Immigration Lawyers Association in the Bahamas. I was the only securities lawyer. I stood up and I presented to a room, must have been 500 or 800 lawyers. And when I finished that presentation and I talked about the various securities laws that applied, I got back to my table. And one of my securities colleagues, my immigration colleagues was upset, extremely upset. And I said, "What's the matter?" And they said, "Oh, they all think it's your opinion. It's just your opinion." Last year, April 3rd, the Immigration Service invited the SEC to speak on the subject matter at a conference for an hour. It was in Washington, D.C., and then it was teleconference. And the SEC took my lecture materials, essentially. Laura called me and said, "I was surprised they didn't pull out your chart." The reason I say that is, if you're going to say, "Oh, this was done, this is what was always done," why they're doing it, or this is what they did in the past, that doesn't work. Because historically, people weren't paying attention. They viewed this program as some special, quote, exemption because it was immigration-based and they didn't have to comply with the appropriate securities laws. And now you're seeing some of the effects of that with some of the litigation that's occurred, that's been brought by the SEC. Now you're seeing heightened scrutiny by the SEC. Now the SEC has liaisons with the Immigration Service and they're actively pulling files to review them to make sure that there's at least no patent, overt defects in the offering documents.
We are now seeing plaintiffs' counsel soliciting EB-5 investors who have been duped or have been hurt by investors, saying, come to us, we'll file a class action. So, it's getting very sophisticated, and we're getting a lot more scrutiny by SEC, FINRA, and plaintiffs' counsel out here.
A few years ago, I started reviewing other, to be a good lawyer, not only do you rely on your own skill sets, but you try to learn from others. We're just an accumulation of our own experiences and those of our colleagues and others in the area. And I reviewed a lot of the paperwork, and I said it really was very, very deficient. And some of the practices of those that were involved in this industry were really improper. And I can tell you now that we as a firm are I've received 2 calls in the last week from lawyers, from immigration lawyers, seeking our assistance as defense counsel because they were receiving subpoenas from the Securities and Exchange Commission regarding certain activities of regional centers, the activities of the lawyers involved in the advice and/or activities referring of clients and getting paid for those referrals. And it's very, very active. I can also tell you that the Financial Industry Regulatory Authority, FINRA, has designated some special individuals to be focused on the EB-5 program because as this industry has evolved and more sophisticated players have gotten involved, you're seeing coming online broker-dealers, licensed registered broker-dealers with the Securities Exchange Commission, which should be used to properly market and solicit investment dollars. So let me go over some high-level things. And again, anybody who has any questions, feel free to ask me either while I'm sitting up here in open forum or afterwards. But I do things by pictures because it's easier for you to hang, knowledge on a hook. So there are 4 areas of the securities laws that apply when you're doing the indirect and induced approach capital raising effect. There's the law that applies to the offer and sale of securities to the foreign investors. Under the EB-5 program, investors are sold an equity position in a limited liability company or limited partnership. That's one of the first tests to demonstrate that they have an ownership interest in a for-profit endeavor and they've made their $500,000 or $1 million investment. So the laws that govern that interaction, Securities Act of 1933, and there are 2 exemptions. The Securities Act of 1933 says every offer and sale of securities must be registered with the Securities and Exchange Commission, i.e. you're doing a public offering, unless there's an available exemption from that registration. And the 2 most commonly used exemptions are those provided by Regulation S and Regulation D under the Securities Act of 1933. Let me take the easy one, Regulation S. To qualify for the exemption under Regulation S, the investor must be offshore at the time the investor is presented with the opportunity or solicited or attempted to be induced to make the investment, and the investor must be offshore at the time he or she signs the subscription agreement. If the investor is a student here in Florida and they are approached to make an investment and then they fly home for spring break or Christmas and sign the subscription agreement, doesn't work. They were here at the time of the offer. If they're offshore and they are presented the opportunity but happen to sign the subscription agreement while they're back in school, doesn't work. They must be both offshore at the time of the offer and the sale. That is the the easiest exemption to qualify for. The second exemption is that provided under Regulation D. Regulation D has an economic test. What Regulation D says is if you meet certain minimum income thresholds or a net worth threshold, you're deemed what we call an accredited investor. What are those thresholds? You either have $1 million net worth, or you make $200,000 a year for the last 2 years, expect to do the same this upcoming year. It's increased to $300,000 with a spouse. So you might ask yourself, well, how in the world does a student qualify for that? Well, typically, the parent will give the child $1 million, and then the child will make the investment. That's how they qualify under Regulation D. There are other, I don't want to go into the details of the Jobs Act and public offering, general solicitation, not. There's other guidelines with respect to these exemptions. I just want you to be aware that there's an economic test. Let me just jump back and say something about Regulation D. If you're engaged in general solicitation, which means you're doing internet advertising, you're basically putting ads in paper, you're doing general marketing, you need to make sure that the investor is an accredited investor. And typically the way to do that, I'm giving you some practical advice versus just espousing the law, is you'll have an accountant licensed in the United States or an attorney prepare a letter saying they've reviewed the appropriate information, and based on their review, this individual is accredited. There's also another area of the law that you need to be concerned about with Regulation D, and that is there are some bad actor rules that came into play pursuant to the Jobs Act. And you need to make sure that certain significant owners of the enterprise, those that own 20% or more, or certain individuals involved in the sale of the securities are not what we deem to be bad actors, people that have certain criminal convictions as a result of securities law violations, people who are no longer allowed to be involved in securities offerings, etc. There's a whole list. And finally, in Regulation D, if you use that exemption, they can be used consistently. You can use both Reg D and Reg S at the same time. So you're allowed to rely on both of those exemptions. So when we write our securities offering documents, they give you that flexibility. You're going to file, if you do an offering and you rely on Reg D, you're going to file a document with the Securities and Exchange Commission called Form D, which will indicate what states those individual investors are located in that made the investment. But most importantly, there's a line that says, did you compensate anybody for making that referral, for introducing that investor? And you need to fill in that information and put that person's name down, and whether they have appropriate license for getting compensated for that introduction. If you don't, you've got a false filing with the SEC, and I don't recommend that. In terms of the offer and sale of securities under the Securities Act of 1933, those are the exemptions, so you don't have to register. But there's other laws that apply to that offer and sale. Just because, let's say everybody's offshore, you don't even rely on Reg D, just offshore. In the old days, people would say, yippee, everybody's offshore. I don't have to worry about these securities laws. They're offshore, everything's offshore. There's anti-fraud rules. And everything I'm telling you now is federally based. You have a whole set of state laws as well. So every time you do these offerings, not only do you have to look at the federal laws, but you have to look at the state laws too. And there's some very onerous states. And you would be very, very surprised. And if you blow a state law, one of the remedies is rescission, which means that you've just basically sold a put to an investor. In California, it's strict liability, and that's in the broker-dealer area. There's not even a defense. And I'll get to that when I talk about the broker-dealer rules. So in terms of the offer and sale of securities, typically when you offer and sell securities, once you've determined that you've got some exemptions here, you prepare a private placement memorandum. That's your disclosure document. What is the purpose of this private placement memorandum? It's to make full, fair, and complete disclosure to the investor about the business, about the investment. What's the economic terms? Who's management? Has anybody on management who has policy decision-making authority, have they had a bankruptcy in the last 5 years or 10 years? Do they have any criminal convictions? What are the things that you would want to know about the investment you're making? And a lot of EB-5 deals are done where a pooled investment vehicle is formed, raises 20, 30, 40, 50 million from a group of investors, And that entity then loans the money to the project company, the developer, that's going to develop a hotel, a hospital, whatever it may be. And so when you put a securities offering document together, not only does that securities offering document talk about the pooled investment vehicle, the LLC and its decision makers, the economic terms, the tax implications of being involved in that vehicle, but it also talks about the risks associated with that investment. But it also talks about the underlying development and the project. What's the risks with the development of this hotel? What about the management of the hotel? Because again, if I'm making a loan, if I'm investing in a pooled investment vehicle that makes a loan, I'm going to want to know about the borrower too. And so a well-designed offering document is going to have full, fair, and complete disclosure about both of those entities and its principles and all the other things that you'd want to know if you were making that investment.
Can I just jump in really quick? What Steve had said about templated documents and how people were putting out offering documents over the past 10 years that may have been accepted, those documents are no longer going to pass muster.
They never passed muster.
They just got away with it.
That's right.
I mean, we just saw a deal last week, for instance, where the deal was on a high-tech company, internet-based sales, and we looked at the draft documents, and one of the white shoe law firms in New York actually was corporate counsel to this project, not on the EB5 area, looked at it and said, what the heck is this? It looks like their franchise restaurant risk factors in this PPM, and they were repeated throughout. It's as if they took it off the shelf and just tried to repurpose it for a high-tech industry, and that would never fly. You don't want your investors to have rescission rights. I mean, their money has to be at risk, but the rescission is a real possibility.
Aside from fraud.
Excuse me, attorneys, for those that are not in the legal field, and what is the offering document?
Okay. So when somebody wants to make an offer and wants to raise money,
And who would that be?
that would be anybody who's interested in accessing capital to do a project. It could be a restaurant owner that wants to expand. It could be somebody who wants to start a new company, though startups are very difficult to do in the EB5 arena. Somebody who wants to build a hotel, a charter school, a hospital. People who are looking for money, and they may have, let's say it's a $10 million project. They have $2 million of their own money ready to do the deal. They may have a bank willing to give them $4 million, so that's 6, they need another 4. And so they're going to have to go out to friends and family, go out to foreign investors under the EB5 program. They're going to go out and raise that additional capital to fill out what we call a capital stack. And so when an individual or a company goes out to raise money, one of the things that that company does is put together a private placement memorandum, which is a disclosure document, an offering document. It's not required under the securities laws when you have an exemption. It's best practice. Because
We will require it.
no, you do. Exactly. But I'm trying to give you the back. So the point is, you're trying to avoid anti-fraud rules. You're trying to avoid a fraud both at the state and federal rule for securities fraud and common law fraud. When an investor says, "You didn't tell me that. You didn't tell me that you didn't go get an MBA from this institution. I thought just from our conversations and how sophisticated you were that you had an MBA. Oh, you didn't tell me this." So you don't want to be in the he said, she said game when you're involved in a securities fraud litigation where your entire net worth and the well-being of your family is at risk, because you cannot hide behind a corporate entity its personal liability. So we use a disclosure document called the Private Placement Memorandum. Yes?
Maria, there's a mic coming your way.
I haven't even gotten to the...
Yeah, and let's do something, folks, because I think that, Maria, go ahead and ask your question, of course, but after that, let's hold off on questions, because I think you're going to hear Steve talk a lot about things that I think you're going to ask. So let him finish, and then we'll open for questions, but please, Maria, go ahead.
Yeah, just for some clarity, for security offerings, whoever does that, they need to have a Series 7 license, because I'm confused in regards to the offering versus the marketing of the project. If you could clarify that, I think we might be more in tune to what else you're going to be saying.
It's an excellent question, which is why I have the chart. There are 4 areas of the securities laws that apply. The Securities Act of 1933 deals with the offer and sale of the securities. So the types of things that you're required to do when you have an offer and sale, does it have to be registered with the Securities and Exchange Commission, or is there an available exemption from that registration? What types of information should be disclosed to avoid a violation of that act for failure? It's the statement of material fact or omitting to state a material fact that would make the statements in your disclosure documents misleading. So if I said to you, I have a building and it's worth $10 million. In the securities world, that would be fraud if I didn't complete the sentence and say, and I have a $3 million loan on it. It affects the economic picture. The second area of the securities laws that you're getting to is the Securities Exchange Act of 1934. A completely different securities law applies to a completely different set of activities and people. And that deals with the marketing of the project, who's permitted to market it, who's permitted to be compensated. So in the 34 Act, which I'll get to, and it's a good question I should have summarized up front, anybody who affects a transaction in securities for the account of another, anybody who's involved in the offer and sale of securities for another party, so officers and directors of a company, third party wanting to raise money for a project company, they're deemed to be broker-dealers under the law. Whether they have to register is if they use any instrumentalities of U.S. commerce, the phone, the emails, the internet. What the law says under Section 15 is it's unlawful to engage in any of those activities and use the instrumentalities of U.S. commerce without being licensed. So effectively, how do you do it? Unless you're completely offshore and are not here in the United States and not using the internet, the email, fax, telephone. The other 2 areas of securities laws that apply are the Investment Company Act of 1940. When we form these pooled investment vehicles, they make a loan or an investment in the project company. That loan instrument or the investment is deemed to be a security. What the Investment Company Act of 1940 says is any entity that's in the business of investing in securities must be registered with the Securities and Exchange Commission under the Investment Company Act of 1940 unless there's an available exemption. And we all design exemptions to make this work. And you'd say, well, I'm not in the business of investing in securities. Well, look at your offering document. I'm forming a pooled investment vehicle, the purpose of which is to make a loan to this project company or to invest in a series of stock of this project company. The whole purpose is to buy a security because the security as defined under the Investment Company Act has a different definition, a slightly different definition than under the Securities Act of 1933. That's why you have to go through all these different securities laws and why I have this chart. Because people think, oh, I complied with one, I'm done. No, there's 4 securities laws that you have to check your box every time you do this. And the final securities law that we look at is the Investment Advisors Act of 1940. And that basically governs the activities of the investment manager, the person, the general partner of a limited partnership, or the manager of the LLC, limited liability company, that has taken in that money to make that loan or make that investment. And those are the laws that govern that particular entity or individual. And the reason for that is post-Dodd-Frank, they implemented this law because we saw the misdeeds of certain people, Madoff, etc., who didn't have certain regulatory oversight. So they made some laws more onerous, which unfortunately makes it a little bit difficult for some of the operators in the EB-5 program because of the requirement or not to be registered as an investment advisor either with the Securities Exchange Commission or the state regulatory agency. So I think that's your question in terms of what's the difference. Series 7. Series 7 is a license that an individual typically gets to act as what we call an associated person or an employee of a registered broker-dealer to help carry out the transaction in securities, the marketing, the sale, the initiation and closing of the offer and sale of securities.
Yeah.
Different area of securities law.
And also remember, I think that again, to keep it simple for some of you, the offering document is the actual document that the person who is in charge of the project, the group, the company that is in charge of the project, puts out to give investors information on the project. And that offering document, as Steve said, has to be very thorough, and it has to, when we submitted our hypothetical for Panorama, that was this thick, because every project developer or the commercial entity, which is where the investment is going to be made, is looked at with a fine-tooth comb. And Laura will go into that, because that is not something that we submit as a city. That's what the investor and their lawyers submit. So there's a big difference there. But when Steve tells you all about the offering documents, the offering document is actually what is the project? Who's behind the project? How much money is being put into this project by others? Correct?
What are the economics, financial terms, the backgrounds of the decision makers, the people that control the corporate governance? What decisions can be made without an investor's consent? What are the specific risk factors associated with this investment, as well as industry risk factors, as well as EB5 immigration-related risk factors, as well as risk factors associated with the offering in general. So there's a whole series of discussions and disclosures that occur in that offering document. It's a huge endeavor. Summaries of material contracts are put into the agreement, because you're going to want to know what material contracts the enterprise is bound by, and risk factors associated with any of those particular contracts. It really, when a securities lawyer does this, they put an offering document together, they ask for a business plan, but then they ask for everything. They want to know, give us every material contract, fill out these directors and officers questionnaires, because we want to know everything we can about the principals making decisions. There's a whole set of due diligence so that in the future, somebody doesn't come knocking on your door and saying, why did you omit this from the offering document? If a client doesn't tell us, they don't tell us. But at the end of the day, we're soliciting all the information, and we're determining, based on our experience, what is material and what is not. Our client shouldn't be making that decision, because what they think might not be material under a securities fraud set of litigation, the laws associated with litigation, it is material, and the plaintiff's lawyer will stand up and say this was material. One of the guidelines we use is the guidelines that are provided under what we call Regulation SK for public offerings. The SEC in the public offering arena gives pretty good guidance under what we call Regulation SK of what they deem to be material. And so good practice would be to make sure that you're addressing those items. Let me move on very quickly again to the pooled investment vehicle, because that's another important securities area, the Investment Company Act of 1940. What I said is any entity that is in the business of investing in securities must be registered under the Investment Company Act of 1940 unless there's an available exemption. Two of the most common, so again, pooled investment vehicle, raise $50 million, loan the money to a project company to build a hotel development. That loan instrument's an investment security. The SEC has confirmed that in that April 3rd conference that I told you about. And my colleagues at the other large, well-known securities law firms concur. I will also mention all the areas I'm talking about right now. Banks make loans to companies. Bank counsel is now requiring legal opinions from the Corporate Securities Council saying that you are complying with these areas, all four of these areas of the securities laws. So this whole industry has evolved. With the Investment Company Act of 1940, there are two primary exemptions we rely on in the EB5 arena. One is called 3C1 exemption, the other is called 3C5C. Just two quick points. 3C1 says you don't have to register as long as you have no more than 100 beneficial owners of your LLC. So that's a $50 million project of $500,000 an investor. If you go beyond that, things get more difficult, because the available exemption that most of us rely on in that arena is 3C5C, a fully secured real estate backed note. So if you have a real estate note with a lien on a piece of property, that works. The problem is oftentimes you have bank financing in the deal, and banks don't like second liens on property. So they want you to do is another financing structure, and I'm happy to talk to you about that after the conference. I just don't want to lose people now when I'm talking about the nuances, but just keep that in mind, fully secured real estate backed note. The Investment Advisors Act of 1940, again, that governs the individual or entity that is making the investment decisions for the pooled investment vehicle, that is the investment company with the exemption. And Suffice it to say, you're going to have to look at state and federal laws to see where you're going to have to register. There are some ways to structure deals that I think, can push the line, and we've gotten, comfortable, but keep it in mind that you just put that in your check the box to make sure that you're complying with that law. And you'd say, well, we're not an investment manager, we're not in the business of managing, investments. You are, because you're making decisions over that loan instrument. You're making a decision whether to call a default, whether to advance the loan if there's certain draws that are made under, let's say you're doing a construction loan, so you are managing that process. And then,
May I just
Yes.
ask you for
Yes.
something? There are a lot of people in the audience that are involved in real estate.
yep,
And since we had said that we were going to go through, we don't have to stop, but I want to make sure we cover the key issues, because there are a lot of realtors. What is the role? What can a realtor do here?
right. So now I'm getting to the Securities Exchange Act of 1934, and I saved it for last because it's the hot button and people usually have a lot of questions. So again, as I mentioned earlier, under the Securities Exchange Act of 1934, anybody who affects a transaction in securities is involved in the offer and sale of securities, negotiates it, facilitates introductions, handles funds, helps work on offering documents and marketing materials. They're deemed to be broker-dealers under the U.S. securities laws. And if they use the instrumentalities of U.S. commerce, basically if they're engaged in this in the United States, or they're making phone calls or using the internet to people offshore, it's unlawful for them to engage in this activity without the appropriate securities license. So you ask yourself, what happens if I'm a real estate broker and I have sold homes to individuals as second homes, but they'd now like to get a visa under this program? And let's say I have 10 people and I call a project company and I say, I've got 10 people for you. I think they'd be great investors and I'd like $45,000 a person. They need to be licensed. They need to be licensed either as a broker-dealer with the SEC or an associated person holding the Series 7, a Series and a 63, or a 63, which is the state license, and a 72, different licensing in order to do this in a lawful manner. There are criminal implications if you do this unlawfully. There are, to the issuer, the company that's taking the money from them, there are rescission rights, meaning essentially you've given the investors a put, so if the deal doesn't go well, they can force you to buy back that interest, and you have personal liability for that. You cannot hide behind your company. The SEC can come after you as an issuer or controlled person, somebody who's making decisions and control.